Section 25. This section of the law relates to the appointment of Assistant Public Prosecutors, AP, in a district. It states that the state government is responsible for appointing one or more APs for conducting prosecutions in the courts of magistrates. Additionally, the central government may also appoint one or more APs for a specific case or class of cases in the courts of magistrates. It also specifies that, with the exception of certain circumstances outlined in subsection 3, no police officer is eligible to be appointed as an AP. Subsection 3 states that in cases where no AP is available, the district magistrate may appoint any other person to be the AP in charge of that case. However, a police officer cannot be appointed if they have taken any part in the investigation into the offense, or if they are below the rank of inspector. In summary, this section of the law lays out the guidelines and rules for the appointment of assistant public prosecutors, and who is eligible to hold the position. It also provides a provision for appointment of other person as assistant public prosecutor in case of unavailability of AP.